morning. Mr. Salgado's coming. There he is. Good morning. Okay, Mr. Ufferman, you're up.
Thank you, Your Honor. May it please the court. Michael Ufferman on behalf of the appellant, John Fesh. I'd like to reserve 5 minutes of my time for rebuttal.
Sure.
I'm hoping to focus my time this morning on the first claim raised in the briefs. And of course, if the court has any questions regarding the remaining claims, I'm prepared to answer those questions. The first claim concerns, in essence, whether or not my client was denied his right to a fair trial as a result of the introduction of uncharged conduct. The alleged victim in this case was my client's stepdaughter. And the state alleged that the purported sex acts occurred between December of 2012 and October of 2014. And in fact, at trial, the state narrowed that timeframe even more. On page 286 of the transcript, which was the prosecutor's opening statement, the prosecutor told the jury that the first supposed sex act in this case occurred in October of 2013, and the final sex act occurred in October of 2014.
Mr. Ufferman, can I interrupt you? Because I'm trying to follow the sequence procedurally, how it was brought before the court. My understanding in this case, that this is the second trial. The first trial, you had it first trial, it ended in mistrial. Is that correct?
That is correct, Your Honor.
All right. And at the first trial, there was this specific Williams rule evidence presented, and the court allowed it to come in at the first trial that ended in mistrial. And now here we are at the second trial. I guess my question to you, procedurally, how was it brought to the court's attention? I'm looking at the chronology. It appears to me, and correct me if I'm wrong, that you had filed a motion in limine to exclude that evidence that was presented at the first trial. Is that how it came to the court's attention?
I believe it was even before the first trial. And just, I want to be clear, I know Your Honor is clear on this, but we refer to it as Williams rule evidence, but it's actually not Williams rule evidence because the state never filed a Williams rule notice in this case, which is a big part of the argument that I'm presenting. What happened was pre-trial, even before the first trial, the state notified the defense that it wanted to present the testimony of my client's biological daughter. The state claimed that the biological daughter would say that she witnessed an incident between my client and the stepdaughter. Of course, defense counsel thereafter deposed the daughter. And although the daughter said that she did see such a thing, when asked about when that occurred, she was adamant that it occurred when she was 5 or 6 years old, which would have been in 2009 or 2010, well before the time frame charged in the information. Based on that.
Yeah, no, I understand what, at least for the, I'm trying to find out procedurally. You're taking the position, and this, I want to make sure I understand, that there was that the court did not conduct a Williams rule before.
Well, no, so Your Honor, so at that point, defense counsel says, Judge, what's actually occurring here is they're trying to present an uncharged act. So we're asking you to exclude that. Now, at that point, of course, the state could have said, you're right, and let us file a Williams rule notice, and then the court could have conducted a Williams rule hearing, but that's not what the state said. The state said, Your Honor, we acknowledge that the daughter has some problems with her memory, but we're not trying to present an uncharged act. And in fact, at trial, we're going to tie all this together. And based on that assurance from the prosecutor, the judge at the first hearing, who wasn't the judge who presided over the second trial, said, I'm going to allow it. Defense counsel even pursued this again. There was a second deposition of the daughter. In that second deposition, the daughter repeated everything I just said. This all, yes, she's claiming she saw this, but it all occurred well before the time frame charged in the information. Defense counsel again said, Judge, this is an uncharged act. And the second judge, or the judge who presided over the second hearing, who was the same judge who presided over the second trial, said, based on the previous judge's ruling, I'm going to let this in. So then we get to trial, and the state doesn't even attempt to argue that what the daughter was going to be testifying about is something that occurred within the time frame. If you look at page 287 of the trial transcript.
And I understand all the arguments in terms of of your objection to that coming in, but I'm just trying to find out, because with Williams rule, basically, was your client placed on notice that this type of uncharged crime or uncharged act could come in? And the posture, as I see it in this second trial, is that I think the court asked, is this a motion for rehearing? And you said yes. In essence, I am asking the court to rehear what was argued the first time. So the judge, for whatever reason, allowed that in. So I guess which then leads me to the next question. You're making the objection that you did not, your client should have been entitled to an actual Williams rule hearing to have the state present that type of evidence. But Mr. Offerman, didn't you in a way present and argued, at least not when I say you, the defense attorney basically objected to all that, bringing everything that you're arguing now in terms of time, and this was before the incident. In terms of notice itself, I guess, where's the prejudice in terms of lack of notice for your client that this type of evidence will come in? Help me out with that.
Your Honor, let me be crystal clear. The pretrial objection was they're trying to bring in an uncharged act. And the state's response was, no, it's not uncharged. Her testimony is going to relate to the timeframes in the information. We now know that's not true. There's absolutely no evidentiary basis at trial that what the daughter testified to occurred within the charging timeframe. The state didn't even make an attempt to show that. In an opening statement, as I was getting ready to quote from on page 287, they acknowledged that the daughter's not going to be able to say when she saw this. And then more importantly, when they questioned her, they don't even attempt to say, daughter, when did you supposedly see this? It's defense counsel who, of course, has to cross-examine this very prejudicial testimony from the daughter, that it's brought out that I am adamant, I am positive this occurred when I was 5 or 6, which is 2009, 2010. This did not occur any later than 2013. It clearly occurred prior to 2013. So then, Judge, you're asking, was there a pretrial Williams rule hearing, or in essence, the equivalent of one? Absolutely not. If there had been a notice filed by the state, then there would have been a Williams rule hearing, and the state would have been required to show by clear and convincing evidence that this purported act even occurred. There's a couple reasons that the state, I submit, wouldn't be able to establish that. Number one, the alleged victim herself, when asked, do you ever remember an incident where the daughter supposedly came in and you asked help and the father said, go get some ice cream? She denies or doesn't remember anything along those lines. But more importantly, the state in its answer brief concedes that this wouldn't even meet the standard for Williams rule. This is page 16.
Hold on, Mr. Offerman. Well, let's delve into that. Would you agree that right now, I mean, we're dealing with a relaxed standard of admissibility, for collateral acts of child molestation? You'd agree with that?
Yes.
Okay. So under that relaxed standard, and I know you made references to some cases supporting your position, and I know the state brought in. So let's just focus on that relaxed standard. Under that relaxed, and let's just push aside any issues or any improprieties or the lack of Williams or whatever. Would the evidence have come in under that relaxed standard of admissibility in this case?
Let me quote from the state's answer brief. And this is page 16 of the state's answer brief. Moreover, MB's testimony was so vague that it failed to meet a bad act or collateral crime classification. The state has conceded on page 16 that this doesn't even meet the Williams rule standard. But and as you've referenced, Your Honor, I've cited cases in my reply brief in response to these arguments that the state made in its answer brief. Again, the state in its answer brief initially said, Herring from the Florida Supreme Court supports our argument. And as I pointed out in my reply brief, Herring completely refutes the state's argument and supports Mr. Fetch's argument. In Herring, the state, in fact, did file a Williams rule notice. There was a pretrial Williams rule hearing. And after the trial court made all the findings that are required under Williams rule, said that evidence can come in. That never occurred in this case. But again, the state is even conceding in its answer brief that it's vague testimony. And again, beyond that, I've cited the Robertson case in my reply brief.
Well, you mentioned Herring and look, and I just pulled it up right now. In Herring, we're dealing with a different familiar victim, the daughter versus stepdaughter. And it was basically, I think my recollection was, it was approximately 20 years apart from the victim in that case. Am I correct in that case?
Yeah, but I think that's a distinction without a difference, Your Honor. Here we're talking.
But isn't the challenge evidence here, we're dealing with the same victim and it's only 5 years apart. And then the alleged acts appear to be substantially similar. I'm just trying to differentiate or to find out McLean and then Robertson. I know you made reference on Robertson, but in Robertson, as I see it, it did not include any sexual crimes and really didn't meet the relaxed standard of admissibility. So help me out. I'm just trying to understand your position, Mr. Hood.
But Robertson certainly stands for the proposition that the appellate court in the first instance cannot conduct the Williams rule hearing. And Your Honor, that's what I hear you basically asking. Can we conduct a harmless error analysis and say that, look, yes. So the premise of this question is it is uncharged conduct, that we acknowledge there's no evidentiary basis to say this occurred during the charged time frame. Therefore, this had to have occurred in 2009, 2010, as the daughter said. But even if the state would have filed that Williams rule notice, we're as the appellate court, without there ever having been a Williams rule hearing below, going to find that the trial court would have allowed it in. Number one, the Robertson court seems to say you can't do that. The third DCA tried to do that in that case, and the Supreme Court said the appellate court can't conduct harmless error analysis by saying had the Williams rule hearing occurred, it would have been allowed in. But again, in this case, it's even different. Yes, I understand it's a relaxed standard, but you have no corroborating evidence, and it would be the state's burden to prove by clear and convincing evidence that that alleged Williams rule act is corroborated. The alleged victim herself is denying that this even occurred. And again, beyond that, the trial court would have to weigh the testimony and go through all this, make a determination as whether it's more probative or too prejudicial. And again, the state on page 16 of its answer brief is in essence conceding it wouldn't even meet the Williams rule standard. So this court, for the first time on appeal, can't say, oh, had the Williams rule notice been filed, we think the judge would have allowed it in. Beyond that, the Robertson court also pointed out that if Williams rule evidence comes in, it comes in with a very specific cautionary instruction that tells the jury to limit that Williams rule testimony. Obviously, there's no cautionary instruction in this case. So and the other thing is
and again, going back to the trial, and this posture kind of was a bit strange because the way it was brought to the trial court's attention, it came up almost like as a motion for rehearing. Was there any request from the defense counsel below to say, Judge, we're asking the state to proceed with the Williams rule hearing? Was anything like that done?
Your Honor, I don't know why defense counsel would do that. And you're putting a lot on defense counsel. This is clearly an unforced error by the prosecutor. I could imagine a scenario where defense counsel wouldn't have filed any pretrial motion and would have said for the first time at trial, hey, they're presenting uncharged conduct. That's not what occurred here. Defense counsel, not just once, but twice told the judge they're pursuing uncharged conduct. The state denied that. They told the judge, no, we're going to tie this in. This is not uncharged conduct. By all these questions we're having back and forth, the premise would be that we're now agreeing that it is uncharged conduct. At that point, the state had at least two opportunities to say, look, we acknowledge in her deposition, not once, but twice, she's clearly saying this occurred in 2009, 2010. While we may think we can tie it into the charged time frame, at an abundance of caution, alternatively, we're going to file a Williams rule notice, and then we can go through the process of determining whether or not we can satisfy the Williams rule standard. The state seems to be conceding in their answer brief that they can't on page 16, but the prosecutor had every opportunity to do that. I don't know what else defense counsel could have done. Not once, twice said, don't let this in, it's uncharged conduct. The state says, no, it's not going to be uncharged conduct. It comes in, and as soon as it comes in and it's clearly established that it is uncharged conduct, defense counsel says, now, look, Judge, it's everything I told you it was going to be. My client's now being unfairly prejudiced. You've got to grant a mistrial. The judge says no. The case law, and I've cited to the Botto case from the 5th District, just came out in December of last year. It's presumed to be harmful error when improper collateral act evidence is introduced during a trial. This isn't just your run-of-the-mill improper, uncharged, or collateral act evidence. This is extremely prejudicial collateral act evidence. At the end of the day, this is what the jury heard. The prosecutor was clear. The first incident supposedly occurred in October of 2013. The daughter was clear. This, what I observed, definitely occurred in 2009, 2010. The alleged victim would have been 9 or 10 years old then. So the jury is being told in a he said, she said case with no physical evidence that my client's own biological daughter is claiming that my client engaged in conduct far worse than what the state's even charging him with. He's charged with first-degree felony sexual battery by a person in familial custody on a 13 or 14-year-old. The daughter is claiming that my client engaged in capital sexual battery with a 9 or 10-year-old. And again, when you look at harmless error, this isn't something that was just referenced in passing during the testimony. The prosecutor, during closing argument, specifically highlighted this testimony and didn't just highlight the nature of it, but also talked about how emotional the daughter was when she presented the testimony. This is page...
And again, the main reason I'm asking all this, because I'm just trying to understand, and I appreciate your position. What would your response be to if somebody would have said, even accepting everything that you say is true, that defense counsel had the basically, even though there was no Williams rule type hearing, all the arguments that were made before the court, everything attacking all of that as to whether or not that type of evidence would come in, has already been done and has been proceeded. It wasn't styled as a Williams rule hearing per se, but in essence, it's like the substance of that hearing was fleshed out before the court. The court denied it. So defense counsel had the opportunity to make all of the arguments before the court. And also, if you look at the trial, did a masterful job in cross-examination. How do you respond to that? That basically, are we talking about form over substance?
No, and I've been trying to respond to that. I
think the question was the evidence even admissible? And as the fact that it was admitted, how harmful was it? I mean, it comes down to that, does it not?
Yes, Your Honor. And again, I can't imagine anything more harmful than your own biological daughter telling the jury that I observed him engage in capital sexual battery on the alleged victim when she was only 9 or 10 years old. And again,
you're at 15 minutes in, Mr. Efferman, so proceed as you wish.
Well, I apologize. I think I peppered him too much. Sorry, Mr. Honor.
Your time is almost up, Judge Kazan.
My goal is to try to convince you, and I appreciate the questions. And again, my response is, Robertson says the appellate court in the first instance cannot conduct the Williams rule hearing when the trial judge was denied the opportunity, and wasn't just denied the opportunity because this came out of left field. Twice pre-trial, the defense brought to the attention of the prosecutor that I think you're trying to present uncharged conduct, and the prosecutor had every opportunity to say, alternatively, you're right. I'm aware of her deposition testimony. To be safe, I'm going to file Williams rule notice. I submit, had the Williams rule notice been filed, there's this talk about, is it harmless? No, I submit, absolutely, the judge would have found that this doesn't meet the Williams rule standard for the reasons I've just said. Number one, it's not corroborated by anything. Certainly, the state can't meet its burden by clear and convincing evidence. The alleged victim denies that such an incident even occurred.
But even if the judge had conducted a Williams rule hearing and allowed it in, you would still be arguing that was error, that this evidence should not have come into this trial.
Correct. And even if a judge would have found that it is Williams rule, at least my client would have been protected by some cautionary instruction that applies in Williams rule cases. There's no such instruction in this case. At the end of the day, the jury is hearing my client's own biological daughter, as argued by the prosecutor on page 957 and 958 of closing. What did she do on the witness stand? She was bawling her eyes out. The prosecutor is confirming to the jury, look at this emotional daughter. I mean, even worse, they said, because you saw her on the witness stand testify against her own father, her own biological father, who she doesn't want to see anymore, who she said was on top of her stepsister. Can you imagine something more prejudicial than the prosecutor highlighting for the jury that the biological daughter is claiming that some cap sex battery occurred years before what was charged in the information? So I know I'm into my rebuttal time. I'll reserve the rest of my time for rebuttal. Thank you.
You have about 2.5 minutes, Mr. Efferman.
Thank you.
Hey, Mr. Salgado.
So, Mr.
Good morning,
Salgado.
Your Honor.
Good morning. So, Mr. Salgado, I peppered Mr. Uverman a lot on my questioning, but here's what troubles me. Why didn't the state proceed and ask for Williams rule hearing in this case?
That's a good question, Your Honor. I think we can look at it a few ways. Perhaps a zealous state wanting to bring in as much evidence as possible. But I think it really comes down, as Judge Northcutt said, as to how harmful was it. And I'm going to tell you that it was harmless. And I'm going to tell you why. Okay, there was 5 counts in the information. And if you look at counts 1 and it was convicted on counts 1 and 3. I'm sorry, 1 and 2, which is during the period of October 4th, 2014. The other counts 3, 4, and 5, he was acquitted on. Okay, so that evidence of NB that took place prior to 2013 was just, it was tenuous. That testimony, NB's testimony was tenuous. I mean, that's really where I'm banking our argument again,
Mr. Salgado, because
yes,
in
ma'am.
this case, the state did file Williams rule on some other matters, and the court
Yes, it
did
did.
read the instruction on the other, but for this particular issue, the court did not. And help me out why Mr. Uferman makes a good point. It's like the state could have very easily made a Williams rule hearing to give people an opportunity to make that argument as to whether or not this type of conduct, this type of uncharged conduct comes in. Help me out.
As opposing counsel said, we conceded that we did not bring in a Williams rule notice. The state didn't do that. But when you take all of the facts in this case, and you see that this MB's testimony, uncharged, not even knowing, and in fact, when MB testified, she didn't know what her stepfather was doing, whether he was disciplining her or not. I mean, that so removed evidence. Again, the state relied, again, convicting on counts 1 and 2, the state relied its evidence based on the admission of MRB, based on a CPT interview that was given several days after it was reported, this incident was reported. The mother who testified, Heather, she testified saying that almost an implicit admission by the stepfather that, oh, this will ruin me. Oh, yes, I'm sorry that I told her to take her clothes off. Also, the victim testified to the deputy when they had moved to Lake County. This was right after that implicit admission by the defendant. The victim told the deputy, yes, my stepfather did this to me. He raped me. When you take all of that, okay, that was enough to convict for counts 1 and 2. MB's testimony, whether Williams rule admitted or not, that was just, it was tenuous. It did not impact the jury, because if it would have impacted the jury, they would have found a conviction on 3, 4, and 5. So for these reasons, the case in reference to issue 1 should be affirmed, the conviction. If I may, I know that I didn't really go into your question in terms of Williams rule. I mean, as opposing stressed a few times, yes, the state did concede that we didn't present a Williams rule. If I may, I'd like to go on to issue 2.
No, yes. Forget the rest of the issue, because this is the issue that really at least in my opinion, is concerning me. So, Mr. Scott, you're basically making an argument that it was so clear with all the other evidence that it's harmless, but it isn't, when we're talking about Williams rule, isn't it a matter of providing notice to the defendant that this is what the state is proceeding in order for them to be prepared to counteract that argument, or to be prepared to bring any type of evidence to attack that?
Yes, it is, Your Honor. It is. Again, whether that's enough to define as harmful or not, it's our position that it is, that it is harmless. Again, based on all that other evidence, based on the fact that the jury was not impacted and did not, acquitted our defendant on issues 3, 4, and 5. But I agree with you regarding the Williams rule.
Well, I don't know when she agree with me, I'm just asking questions, because one of the things too, Mr. Salgado, is that when we're dealing under the relaxed standard, and I asked that same question of the appellant's counsel, under the relaxed, in fact, let me tell you exactly, the relaxed standard of admissibility for collateral acts. What is your position? Is it your position that under the relaxed standard that this type of evidence would have come in?
Well, again, looking at the evidence, when MB was questioned, she didn't really know what was going on. So whether we could even say that we don't know if it was an uncharged crime. It could have been the stepfather disciplining the child at a time. It wasn't until through questioning that, okay, now that I'm 15 years old, it does seem that it appeared sexual. So with that being said, Williams' rule may not even be applicable because it was just in the way the judge ruled, there was an observation that was made. And the trial judge said, there's enough fodder there on, you have enough fodder for cross-examination. And that's why the trial judge allowed it, not only in the first trial, in limited hearing, but in the second one too.
So as I understand what you're saying, that Williams rule, it's not an issue for Williams rule, Mr. Salgado? Is that
well, we can make that argument that it's not an issue for Williams rule because again, of MB's testimony where, well, I don't know what was going on. And also it's also vague in terms of how old was she when she saw this? Was she 4? Was she 5? Was she 6? And
what was the issue that evidence went to, Mr. Salgado? If it wasn't Williams' rule, or even if it was Williams' rule, what was the issue in the trial that evidence went to?
Well, it was just again evidence of observation of what the child had seen. Again,
yeah, but what was its probative value?
Oh, to corroborate what had happened.
To corroborate what had happened several years later.
That's correct.
And it did so how? Maybe by propensity?
Well, I don't want to admit to propensity because then
of course not. Of course not.
I mean, it's a slippery slope there. But again, I mean, I have to emphasize.
Well, here's the thing. At the time, this child did not see it as a sexual act, and then later saw it as potentially a sexual act. Really, based, one would argue, because of the later charges. But the victim of the later charges, the alleged crime, said, "Oh, that never happened."
That's correct.
So, it's kind of a circular, it's corroborating the victim who says it didn't happen.
Which we conclude that as a result, this whole testimony from MB was tenuous. And that's where we're going to lay our hat. And based on that, we believe there should be an affirmance. There was clear, defendant was acquitted on those counts. On those counts where you see the dates, sexual activity with a child between May of 2013 and October 2013, December 2012 to October 2013, and December 2012 to 2014. And that's when MB saw, what she saw. And again, even
she said it was
earlier
when she was much younger than that.
Yes. Even more reason that it's tenuous.
But the defendant was convicted of 2 counts. 2 counts? 3 counts?
That's correct. He was convicted of count 1 and 2, which specifically reads that on October the 4th, 2014. On October the 4th, 2014. And that's where we have what I believe is overwhelming evidence of the CPT interview that took place shortly thereafter, where she tells the child protection person, yes, this is what happened to me.
But this was a he said, she said case, was it not? And and you've already suggested then that the testimony of the stepsister, half sister, whatever she was corroborative. Correct?
That's correct. But then at the same time, the stepsister says, "Hey, I don't remember, seeing my NB when it happened." But I wanted to again mention the compelling evidence of the mother and what she had said, which I believe is almost an implicit admission by the defendant that something happened. And when he says, "Don't tell, this will ruin me," if you add all that together, again, it clearly finds him convicted of counts 1 and 2.
Mr. Salgado, here's the problem. The jury, with the fact that all this evidence came in front of the jury, I know you're arguing that there's overwhelming evidence. We don't know what triggered the jury to make the decision the way it did. And perhaps it could be argued that this type of evidence, that especially without having an instruction given to them, was problematic and could very well have contributed to them finding the defendant guilty of those count 1 and 2. How do you respond to that?
Well, if it was contributing, then why wouldn't he have been convicted of counts 3, 4, and 5 that applies to the date in question? That's how I see that. I mean, yes, I know that opposing counsel mentioned the comment in closing. In closing, it was really during the rebuttal closing where defense counsel does mention, well, you know, the biological daughter and that type of thing. But again, you know, the jury saw this. They watched a video, the CPT video. They heard the testimony from these witnesses, from the deputy that interviewed her shortly after it was reported. I mean, yes, I think it's a little bit more than he said, she said. And
I guess
again,
what I'm troubled, Mr. Salgado, what makes no sense to me, the court conducted Williams' rule hearing on these other matters. Any idea as to why it was not conducted on this particular one? And I know I was asking counsel the posture, how it came up on a motion for rehearing. I'm just trying to understand that the state did not seek Williams' rule on that particular.
Well, again, the trial court felt that, you know, just saw this as not an uncharged crime, not Williams' rule. The trial court saw this as an observation made by the biological child, MB, and that the defense had the opportunity to thoroughly cross-examine MB on it. And so, again, you know, whether the trial court, you find the trial court, yeah, they perhaps erred, it does not take away the fact that the error was not that prejudicial. Under the circumstance, it was not that prejudicial to require some kind of reversal or to try this thing again. And that's our position. I believe you don't want me to touch on issues 2 and 3.
It's up to you, Mr. Scott. I don't know what my fellow judges.
Okay, I mean, issue 2 was the part about the expert opinion, Val Gill, that, you know, that we believe that testimony aided the jury in assessing the veracity of the victim of child abuse, and it helped to rebut the defense attacks on the victim's credibility. We cited case, and by the way, they did not even reserve on that. By the way, I think they just filed they had a motion to strike the witness Val Gill, and that testimony, Val Gill's testimony, was based on her training and knowledge and experience. Was pure opinion testimony just for the purposes of, you know, children that experience these types of, you know, sexual abuse. You know, they're going to give their testimony piecemeal. It may not be straight through. I mean, I don't think there's an issue with 2. Issue number 3 really regarded the order on a motion to the sentencing. They were saying that the sentencing, there was error in the sentencing because in the order denying the motion for post trial release, in that order there was a mention of oh yeah, there was an acquittal. Well, you know, our position that's pure speculation that the court would rely on that. Okay, that the court would rely on that in its sentencing. And when you look through the sentencing transcript, there's no such thing mentioned regarding the acquittal. Again, that was a Scribner's error, essentially. And issue number 4 really is a cumulative of all of the 4 issues. But I know that we spent most of our time on issue 1. And again, we know that a mistrial motion is granted only when the error is so prejudicial as to vitiate the entire trial. And that error was not that prejudicial. It did not vitiate the entire trial. The defendant had a fair trial. And with that said, we ask that this court will affirm the conviction and sentence. Thank you.
Oops. Thank you, Mr. Salgado. Okay, Mr. Efferman, you're up for rebuttal.
Thank you, Your Honor. May it please the court. Let me just summarize where we are procedurally. The state is conceding that this was an uncharged act. Despite some prodding by the court just now in questioning, the state is in no way attempting to assert that this is a harmless error from a Williams Rule standpoint, that had we filed the Williams Rule notice, the judge would have allowed it to come in under that basis. That the state was given the opportunity just now to go down that route, and they're saying we're not pursuing that either. Their sole argument, I think he said, we are laying our hat entirely on the assertion that the introduction of this uncharged act was harmless error. I submit that the state's assertion regarding harmless error in this type of context regarding collateral acts would turn the harmless error analysis on its head. Again, I've cited to the Botto case. This is the 5th DCA, but this repeats numerous other courts from around the state that have said this over and over again. Quote, the improper admission of similar fact testimony is presumed to be harmful error. The harmless error analysis requires the state to prove beyond a reasonable doubt that the improper evidence could not have impacted or affected the verdict. There's no way the state can meet its burden in this case. The state keeps talking about how the daughter's testimony was tenuous. If it was so tenuous, why did the state not once but twice pre-trial fight so hard to get it in? Why did they put the daughter on as the first substantive witness? And why did they spend so much time in closing going over in detail that his own biological daughter is claiming that this occurred? They didn't think it was tenuous. The prosecutor below didn't think it was tenuous. The prosecutor knew that this is a close case. We have no physical evidence. Despite what my distinguished colleague on the other side of the aisle is saying, this is a he said, she said case. This is only the alleged victim's word. I don't care whether it's repeated to the first reporter or the CPT interviewer. It's still her word claiming this occurred. The defense put on an argument that she had a reason to fabricate these allegations. So there's this assertion that he's made that's referred to as an implicit admission to the mother. My client adamantly denies that. There is no physical evidence. There is no other eyewitness other than the improper admission of the daughter's testimony from something that occurred years before. This was extremely prejudicial. The normal case, it would be presumed to be harmful error. It would have to be a unique case for the court to find that this doesn't fall within that presumption. This falls on the other side. This is so extremely prejudicial to have your own biological daughter tell the jury that my father engaged in capital sexual battery when the alleged victim, not when she was 13 or 14 as charged, when she was only 9 or 10 years old. So that clearly corroborated in the mind of the prosecutor and ultimately in the minds of the jurors, her allegations that otherwise were not corroborated. But because it was improper testimony that should not have been admitted, my client did not receive a fair trial. The proper remedy is to reverse for a new trial. If the state can move forward at a retrial and establish that by filing a Williams Rule notice and showing that they meet that standard, then so be it. But they've conceded that they can't. So my client is entitled to a new trial. I'd ask this court to reverse. I see you nodding. I must be done with my time. Thank you.
Yeah, you remind me of myself back in the day. Thank you, Mr. Efferman. Thank you, Mr. Salgado. In order to leave, recall that you leave our virtual courtroom by clicking the leave button in the, I think it's the lower right-hand corner.